Good evening, guys. This side Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multinational headquartered group based out Singapore. Professionally speaking, we are a multi-asset and multinational hedge fund, which effectively means that we cover variety of positions like gold, silver, platinum, palladium, oil, natural gas, base metals, agriculture metals, foreign exchange, and equities. We cover our positions at three places, which includes United States, European Union, and respective. But like I repeated many a times, and I would continue to repeat all the times that we are a proprietary hedge fund. By proprietary, I mean to say no third party. I repeat, no third party can invest capital in our fund. None of the subsidiaries of Treasury Consulting is inviting any form of third party investment. Please do take a note of that. Today, I would be covering, my legal desk would be covering a very important topic which is called intellectual property infringement versus challenging of intellectual property. Both are completely different things, but unfortunately, a mindset has been created that both are same things. So first of all, let me clarify a small difference, then I'll expand. Example, you are holding iPhone. iPhone is developed over the years. All the patents, software, hardware is in the hands of Apple and associated companies of Apple. But what would if you start copying the logo, which is half Apple, of the Apple Inc., and start pasting on your own phone? You know, people feel that this is a phone by Apple, but actually it's a local phone because Apple phone is different than what your phone. Now, this is called infringement of intellectual property. Now, it means that you are doing the infringement of design, probably copyright, I would say, or a trademark. But having said that, challenging of intellectual property is a complete different thing. It's a complete different thing. And sometimes companies themselves initiate this. I don't want to quote any specific company, but in the last couple of years, a trend has been made, at least in the United States, when the technological companies, when they launch their product in the public, at the same point of time, they invite the hackers, they invite the software developers, they invite the coders to come forward and find out the mistake in that device. And if you're able to found the mistake, then the company will remunerate you a job, maybe a very heavy price, certificate of appreciation, and maybe whatever. The former case, when you are a phone company and you using the design of Apple on your phone, this is called infringement of intellectual property of Apple Inc. In the later case, Apple himself is saying that I launched Apple iPhone 15, example, just an example, and I'm inviting the coders, software developers worldwide in a conference, assuming happening in US. You come there and you show that there is an error in the mobile phone, and if you're able to bring out the error, we would compensate you appropriately. This is called challenge of intellectual property. Sometimes challenge is after the product launch also. So example, Apple iPhone 15 is there in the market. You are a software developer. Proprietary software developer means you write codes for companies, you sell them, you don't work for any company specifically. You using Apple iPhone, and you feel that if this code would have wrought this way, the phone would have little better. So you challenge Apple and say that if the code would have wrought this way, the speed of the phone would have increased by 2 times, because you feel that. Now remember that when you are challenging the intellectual property, take a very very due care of that. When you are challenging the intellectual property, because the company not invited you to challenge that intellectual property, you are actually inviting defamation, provided you not been able to produce that, you not been able to substantiate that. So example, you are using iPhone 15 and you saying that, guys, if we able to write this code that way, we would be able to increase the speed by 2 times. But you not been able to write the code, and you failed in writing the code, then Apple would defame you. Take a note of that. Immediately Apple would defame you. In many countries, defamation is civil, defamation is criminal, both. But some countries have only civil defamation, some countries have criminal defamation, but many countries have both kind of defamation. Please do take a note of that. So please take a note of that. Intellectual property challenge is not, illegal in nature. Unfortunately, few people in the system made this illegal. That if you are challenging, you are illegal. Example, I have seen enough of times when the young kids just college pass out, they challenged big companies, their systems, their brands, their products, their devices, and they proved that if the relevant thing done that way, that relevant product would have much better than what it is today. But remember that once you are challenging, please be very careful, have complete due diligence. You should know your facts, each and everything. Please do take a note of that. Like I personally also challenge intellectual property, the banks, financial institution, their structures, their definitions. Just like very recently, I challenged Emirates NBD, one of the best banks as far as Dubai is concerned. That the way they are representing the fair value hedging is incorrect. Because I personally done fair value hedging for not few months, 7 years. 7 years. So I know that how exactly it works. And the way they're representing is not a correct representation as we speak. Anyways, that's not the point to discuss now. Please understand that intellectual property infringement is of many types. There is not a one type of intellectual property infringement. You can have n number of types, so don't expect I'm able to cover everything in this regards in one video. Generally, infringement are done as far as the copyright is concerned, as far as the design is concerned, rights are concerned, patents are concerned, trademarks are concerned, and related actions are concerned. But remember that there is a very hairline difference. I repeat, hairline difference between infringement and exploitation. That's a very hairline difference between infringement and exploitation. Example. Suppose there is a big telecommunication company in US, and generally these telecommunication companies have outsourcers. They outsource their products, their devices to cheap locations like Vietnam, India, Philippines, where the labor is cheap, the exchange rate is manageable, and companies would be able to bring the same device in a very cheap manner, and they get good profits. Also, it's a win-win thing, to be honest. Just like India is a place of information technology, while Vietnam is a place of hardware, China is a place for manufacturing. It's a win win situation for both the countries, both the parties and countries. Nothing wrong in that. Suppose that technological company has outsourced their processes to a company in Vietnam. And what would they agreed that the Vietnam company, would be doing, I would say, producing 100,000 phones per month, assuming. But that technological company get to know that the Vietnam company is producing 100,000 phone, but what is happening that Vietnam company has taken additional contract of their competitor. Suppose the competitor is Mr. X, and that Mr. X product designing is also happening in the same premises where the product designing of that technological company of US is going on. This is a conflict of interest, which means they are exploiting the intellectual property, which means that in this eventuality, there is a full probability that the intellectual property of that company would fall in the wrong hands, because the process can be compromised very easily. Now, having said that, officially speaking, that company in the Vietnam not sold their design or probably the software code or the hardware part to the other company officially. What they did, they just manipulated it and they let their competitors designing in the same premises where that existing company is going on. So please do understand that there is a very hairline difference between the infringement of intellectual property and exploitation of intellectual property. Unfortunately, just like we have expert agreements, we have arbitration agreements, and people feel that both are same. No, both are not same. They are completely different. Courts are having limited jurisdiction in expert agreements, while in arbitration agreements they have unlimited jurisdiction. Example, they can even reach till injunction, anti-suit injunction, anti-suit injunction, anti-enforcement injunction, and there are n number of things. While in the case of expert agreement, courts have limited jurisdiction, though they have jurisdiction. Similarly, in case of exploitation of intellectual property, things are little different as compared to infringement of intellectual property. And to be very honest, it is very difficult to prove that we are talking about exploitation of intellectual property. Very difficult to prove in the court, because it is easy to prove that the exploitation is happening. Easy to prove, not a difficult job. But regarding the exploitation, it is a very cumbersome job. Henceforth, when you are reaching to the court of law, as far as the intellectual property is concerned, please be very careful. You're talking about exploitation or you are talking about the infringement, because many countries have different laws for both of them as far as the prosecution is concerned. And unfortunately, even today, the text or the languages which is being written covering the exploitation is limited, while the text and languages written as far as this infringement is concerned is very much as compared to exploitation. So please be very careful. But probably in the next part I would be covering how you can stop the exploitation automatically. There is a way out. You can stop the exploitation automatically, but of course you have to be very careful, you have to be very vigilant. But if you are not careful and vigilant, then both infringement and exploitation can happen at a given point of time. I'll see you in the next part and I'll let you know how you can defend that and other important things in the intellectual property. Please understand that there are few businesses we have in the world where intellectual property infringement and exploitation is very common. Very common. And courts are filled with these kind of allegations. And especially in the software industry. So I'm taking a hypothetical example. I repeat, it's a hypothetical example. Software is made by Microsoft and it is infringed by some other company. In aviation industry, which is more complicated than software industry, you made a very very complex engine designs, tried and tested, millions of dollars are being invested in the engine designing, combustion engines and all these, and it got leaked. Everything is gone. All effort is gone. Automobile industry, you spare a huge amount of money in designing of a vehicle, the seat structure, the gear, the engine, the outer look, the inner look. Before you came up with the first vehicle, the demo vehicle, it is leaked. You know, the space industry, just like you have NASA, you have various other space associations, they are doing years and years of research, on the space, on a relevant objects in a space. It is highly confidential, cannot be revealed in the public. The investigation cannot be revealed in the public, it has to be confidential, and somehow it got leaked. Sports industry, when you work very hard, you make some sport design which will help the sports people to play in a little relaxed manner, which will increase the productivity of any football, cricket or baseball or whatever team, and all of a sudden this design is leaked or infringed. There are many industries which we have in the world who are always susceptible to the intellectual property infringement. Always susceptible to intellectual property infringement. Rather than waiting for that infringement, they supposed to be very, very careful in nature. And that is really a big, big, big example we need to set. And everything lies in two things. I repeat, everything lies in two things. You just have to follow two things, and majority of your job is done. First of all, we need to appreciate that although majority of the countries in the globe are having respective intellectual property policies. I'm not naming any specific country, but many countries of the globe have respective intellectual property policies. But unfortunately, these policies are only on paper. The practical implementation of these policies is zero. There are many countries in the world who are known for copying the intellectual property of the big countries without having any fear. Reason being, I don't want it to say, because they knew the loophole of the judicial or the legal system. Similarly, there are few countries in the world, example Singapore, example English law, example New York law, who are very strict as far as the intellectual property infringement is concerned. And especially talking the New York law. We have seen that in New York, even the big takeovers of several billion dollars being halted by the judiciary. And this is not first time. Many a times I noticed that the big M&A, for the sake of anti-competitive practice, they being halted by the judiciary. Just like we have seen in case of Twitter very recently, when Elon Musk first said that he willing to buy Twitter, and then his nature, and then he again created the hype of Twitter, and then again no, Twitter went to court. When they went to court ordered that Elon Musk have to buy the Twitter, and later on he bought at 44 billion US dollars. Now that is something else, that after buying of Twitter, what he did with the Twitter and what is happening with the Twitter, the whole reputation is at stake. many jobs are being lost. That's a complete separate thing, but that can also be taken care of. Remember, in M&A we have a clause that post I repeat that in M&A we have a clause that post takeover IP, fallout, which means that suppose X company is taking over Y company. Now, whether this is a willingful takeover or this is a hostile takeover, now that is separate. After taking that, the company who bought this basically, they just wanted to destroy this company because of their ego. So X bought Y and X bought Y. Now X is not very happy. X wanted to destroy Y completely, because of their ego. But in M&A, we have a clause that post buyout IP fallout clause, which means if you're signing this clause at the time of M&A, which means if X bought Y, Y can sign this, Y can force X to sign this clause, provided, Y is in that situation. That is another thing of the law. If after X bought this, Y reputation fall out, then X have to pay for this. Please take a note of that. Please do take a note of that. Please take a note of that when you are in this complicated businesses, just like software business, hardware business, technological business, space business, pharmaceutical R&D business, automobile R&D business, highly complicated business which requires heavy investments, research, and everything. Always remember that Singapore, English law, and New York law are the most important thing to cover. I know that the flip side of that is the cost. I completely agree that if you're going with Singapore law, if you're going with European law or New York law, they are expensive. I'm not defending this. They are expensive. I completely agree. Expensive as compared to the other Asian countries, but having said that, they are foolproof. They will give you justice, and they prove that on a sequential basis. Even the big M&As being halted on the ground of anti-competitive practices. Heavy fines, heavy fines, several billions of fines being imposed on IT companies for their wrong practices. But please do take a note of that. Your contract, which you are signing with your vendors, your outsourcers, probably your clients themselves, you need to be very particular about these things. But if you are not particular, you are bound to fail. Because law taught you many times that contracting is not a science, it's an art. But unfortunately, what is happening, people treat contracting as a science but not an art, which means there are standard 5-7 clauses which you're supposed to put. You put these clauses and forget. No innovation, no new thinking, no use of mind, nothing. And result, when there is a mess, there is a mess. Simple. Please do take a note of that. I always prefer the contracting should have very strict governing law, and I always prefer New York in this regard. Seat of arbitration, that's very important. Arbitration means alternate dispute resolution. Alternatively, the seat of arbitration, I always recommend Singapore in Asia. The reason being, Singapore is a hub, and being a hub, it is centrally located. Talent pool is there, and it is not as expensive as we have Europe and New York. But having said that, you should have that level of knowledge, vision, and able to have the sense of securing yourself while you are doing the contract. This is what I would like to cover when it comes to IP infringement and so many things. This is Rahul Magan from Treasury Consulting Group. You knew my personal number +91 9899 242 978. You're welcome to visit our fixed income platform www.fixedincome.global. I repeat, www.fixedincome.global. Thank you very much, guys, and have a great time ahead.